I can't keep up with all the myths out there, but I'm going to give you the big one today, which is, hey, John, I was never read my Miranda rights. Therefore, won't my case get dismissed? Won't that help? And unfortunately, I hate to be the bearer of bad news, and a lot of times I am. The answer is no. 99% of the time, they do not have to read you your Mirandas. And even if they were supposed to, there are some issues there, which I'll talk about later. But let's talk about when they have to read these, because they don't have to read them 99% of the time, but under two conditions they do. First of all, if you are in custody, and second of all, if you are being interrogated while you are in custody, then yes, they must read you your Miranda warnings. Now, here's the thing. Some of you, bless your heart, you are in the back seat of the cop car and the cop isn't saying anything. You know, their radio's blurting out random numbers and just stuff going on. And then you blurt out, hey man, I only had like 4 drinks over 3 hours. They weren't that strong of drinks. You know, sometimes you have a strong drink and you don't have a strong drink, and that comes to bite you in the rear end later, right? And you're like, yeah, but they didn't warn me that statement was going to be used against me. Folks, even though you were in custody and you were in the back seat of a cop car when you said those bad things, the problem is you weren't being interrogated while you were in the back seat of that car, because the essence of interrogation is that they are asking you questions. If you just spontaneously blurt out, I never thought I'd get pulled over, I never thought you'd catch me, well, that's a random spontaneous statement. You don't need warnings for that. That's coming in against you. So the other thing about Mirandas that are kind of interesting is, even if they were supposed to read them but they didn't warn you and they were supposed to, that doesn't mean your case will be dismissed, unfortunately. What that really means is that the prosecutor can't use that statement. That's all it means. If they have video, if they have DNA, if they have 4 eyewitnesses, the fact that your statement is not coming into evidence won't mean that your case is going to be dismissed, right? Your case might still move forward. Maybe they can get a conviction even though we stop them from using your statement. So that's a big myth. I hope that I've cleared some of that up for you guys. And I do thank you for watching. And my web people get very angry at me when I don't mention what I'm about to mention, which is if you get in trouble in Central Florida. By that, I mean Orange County, Osceola County, Seminole County, Lake County, Volusia County, Brevard County. I'm here to help. Please give my office a call. And I thank you for watching. Take care.